3 preliminary trial matters. Hearings are scheduled for 1 hour. Ms. Smith, I don't have a preference on what order we handle your motions. Would you like to address first? Mr. Johnson, my apologies.
No problem. Tagging on the first motion, Alex Johnson for the defense. We'd like to address defendant's motion to remove newspapers from courthouse during pendency of proceedings.
All right, thank you.
As to argument for this motion, defense did have pre-marked this morning, and I would move into evidence as defense exhibit 1, what's been pre-marked as defense exhibit A. A copy of the Osceola News Gazette that was present in the lobby this morning, which directly addresses the Stephan Sterns trial to begin July 22nd on the front page of the newspaper of the whole.
State has no position, Your Honor.
Thanks. We received the defense 1 for purposes of this hearing.
So, as to this motion, with the recent denial of the motion to continue, the trial is set to begin next week in this courtroom. And as jurors, potential jurors and jurors that are selected in the trial walk into the courthouse, right in front of security or right beyond security is a slew of newspapers, including newspapers like the Osceola News Gazette, which every time we've had court appearance, Stephan Sterns has appeared on the front page of the newspaper, and the newspapers constantly indicate that there's both a sex case that is currently pending, which is what we're here for this morning, as well as a capital murder case. So defense is requesting that just during the pendency of the trial, not ongoing standing order going forward, that we remove these papers so that way the jurors are potentially as they come in and go about the courthouse.
All right, the state takes no position. I have confirmed with jury services that jury services do not provide newspapers to potential jurors. Court always has to be careful balancing the right to free press and the right to open and fair jury trials. I do find that should there be newspapers available where the jurors can you give me some guidance as to where this table is downstairs? Is it over by the employee area? Is it where the general public would come in?
It's where the general public comes in. It's so if you're looking at the first floor, there's the area where you go to the elevators, and then there's the mirror there.
Yes.
It's the table's right in front of that. Security.
Progress screens.
Yeah, exactly.
I have inquired as to our court administration who provides the newspapers. I think that's a county function. We have proactively reached out to the county to see if we could suspend the delivery of newspapers during the jury selection process and throughout the trial. So your motion is preliminarily granted. The court will direct the parties that provide the newspapers not to do so during the jury selection or trial process.
Thank you.
Smith?
Yes, Judge. Defense would next like to proceed on the defense's motion to order all media to adhere to the rules of judicial administration and administrative order. Essentially, Judge, defense is asking, according to, as the rules require, that the media, and since defense is on the left side of this courtroom and the media is positioned directly behind us, their cameras, intentionally, inadvertently, I'm not saying that they're doing it intentionally, is focused on counsel's table in order to get views of Mr. Sterns and things of that nature. So in positioning, counsel's computer screens are in view of the media. So defense is requesting that the media not be allowed to look at, zoom in on, or otherwise project essentially onto counsel's table because of work product and attorney-client confidentiality. I understand that attorney-client confidentiality, we have to essentially affirmatively attempt to protect it. communications between attorneys and their clients, between counsel and co-counsel, or anything is held at the bench is required not to be recorded or broadcasted. So the defense's position that anything that is occurring essentially at counsel's table in terms of notes, whether that be handwritten notes or computer screen notes, not be looked at. The defense has taken affirmative steps to have a privacy screen and additionally dimming the lighting on the laptops. However, even with that, it still is viewable for the media, and sitting in court with dim screens and dark lights for multiple hours is going to cause headaches, but also to protect not only Mr. Sterns' confidentiality, but potential other clients' information who we're working on while here in court, because the media not being allowed to look at and zoom in on computers or counsel's private computers.
Your Honor, the state doesn't have a position. However, I think if the court is going to issue an order, it needs to be to everybody in the courtroom, not just specifically media personnel.
Are you saying to the state as well, in terms of media personnel, or anyone not being able to look?
There's a lot of amateur media people that will cover this trial, and they use phones, from my experience in other high-profile trials. So the order should be broad enough that it covers everybody in the courtroom, perhaps even an order that people in the gallery should not be allowed to have their phones out during the trial. Yeah. Sometimes they need daily reminders, sometimes they need multiple daily reminders, but they also focus on the state's computer, and we are obviously against that for the same reasons.
No objection to the motion.
All right, our relationship with the media has been a good one. They're an essential community partner, and as I said, the court's going to strive to ensure that this is both an open trial and a fair trial. The days of passing notes back and forth are behind us. A little experience working with each of the attorneys here. I know that your coordination with witnesses, with each other, with presentation, with evidence is highly computerized. We'll expect that the media will comply with Florida Rule of Judicial Administration 2.450, as well as our Administrative Order 2023-23. That order is fairly specific. Under subsection 2E, indicates that representatives may not cover sidebar or bench conferences, no recordings of conferences or information that occurs between attorneys and their clients, between co-counsel, between counsel and the presiding judge held at the bench. I've done several trials where the media was involved. The only violations of 2.450 in our administrative order, in my opinion, have been inadvertent. Issues were when a camera operator perhaps went to a wide shot that included faces of the jurors during the trial, or there was a microphone that was inadvertently picking up communications through the microphones at counsel table after the microphones had been apparently muted by the attorneys. These are technical issues. We have a technical team here that the media is absolutely welcome to coordinate with. The administrative rule gives the media an opportunity to meet with our court administration if they have any questions about what the court's expectations will be. The court will expect that the media representatives will be credentialed pursuant to the rule. Non-credentialed members will not be permitted to have out cell phones as members of the general public. So I see no issue with the defense's request to have the media comply with the rules that are already in place, and the motion is granted. If representatives of the media have specific questions, they may contact my office. I will direct them to our court administration personnel, provide a copy of the administrative rule, which I'm sure they are most familiar, and judicial rule, Florida Rule of Judicial Administration 2.450. So the court will expect that that will be scrupulously followed in an effort not to impede the fairness of these proceedings.
And then the last one is the physical restraint,
Thank you. State, do you anticipate presenting any witnesses in support of restraints?
The state just has one witness.
All right, thank you. I'm ready.
Deputy Richard Rosario.
Thank you.
morning. Will you spell your first and last name for the record?
Yes, Ricardo, Ricardo. Last name is Rosario, Rosario.
How long have you been employed as a court deputy?
Since March of 2017.
And is your primary assignment to this courtroom that we're actually in right now?
Yes.
Are there policies in place for the use of any type of restraints during a felony criminal trial for an accused?
That's correct.
And how many felony criminal trials have you participated in as a court deputy?
Numerous countless, I can't remember how many
That's fair.
I've worked for.
What type of devices or restraints are available that would be out of the view of members of the jury?
So each courtroom has one device is kept downstairs in the first floor, which is a stun cuff, and in the courtrooms we have a leg brace.
How is a leg brace utilized by court deputies during the pendency of a criminal trial?
So a leg brace is essentially a long bar. It has 4 straps. And in the center, there's a tab that you can pull so the person can sit down. Otherwise, the bar won't bend. So basically what happens is when the person sits, it bends, but when they stand up, it just locks. And it prevents the person to run away. They would have to essentially hop away because that leg is stiff.
What is the purpose? Let me ask you this. Are there any safety concerns for you as a court deputy in this courtroom should a accused during a criminal trial not be equipped with such a thing as a leg brace?
That's correct. So when any inmate is brought over to the courthouse, they're in restraints, handcuffs, and leg chains. When they're brought over for a trial, they are dressed out in proper attire, suit, and at that point, they're in the custody of the sheriff's office, and we have to maintain a level of safety and security for the inmate and as well for everybody else in the courtroom. So that's the reason why we utilize those restraints.
Is there limited staff here at the courthouse for the sheriff's office?
Yeah, so in a perfect day, the felony courtrooms would have 3 deputies. A misdemeanor courtroom would have 2, and civil would have 1. But due to staffing, sometimes people take off or they're sick, and it creates a safety hazard if we're running a high-profile felony case with just 2 deputies. So hence the reason why we use also the device.
Is this device something that is visible to anybody that is looking at the outer appearance of an inmate that's wearing it?
No.
Is this device something that delivers a shock or pulse of electricity or anything like that?
That's correct.
It does or it does not?
It does.
It does. When does that happen?
So if I may, I have the device in front of me.
Would utilizing the device assist you in explaining how it operates?
Yes, ma'am.
Go ahead.
So essentially, this is a stun cuff that's wrapped around a inmate's ankle and is tucked away under the clothing. There are 2 metal pieces here that is close to the subject's skin, and the strap is placed accordingly and wrapped not tightly but snug that it won't fall off. The remote is this right here, which is kept at all times with a deputy within the courtroom. Nobody knows who has it. It's hidden discreetly. No one sees it. To activate this it's a two-step process. There's on, and then there's fire. So the device won't accidentally fire on itself. It has to have a two-step button to fire the device.
And the device isn't triggered by movements of an individual or anything like that either.
That's correct.
And is this something that is utilized by court staff in addition to the leg brace that you described?
It's one or the other.
So there's two options that are potentially available to court deputies depending on the scenario.
Correct.
And both of these options are outside the view of anybody that is looking at the outer appearance of an individual as long as they're wearing pants.
Correct. So when we put these devices on the inmate that's scheduled for trial, it's out of the view of the public. It's out of the view of the jurors. No one knows that the person set for trial has it on.
And let's talk a little bit about writing utensils. If there is an inmate present in court, are they given a writing utensil?
Yes, they do. They get a flexible pen.
And those flexible pens are made available by court staff to individuals that are participating in the criminal trial process?
Yes.
And what is the purpose of court deputies providing that specific type of writing utensil?
Essentially, the pen, it does write well, but is used sort of for a safety purpose in the event that the inmate would like to use it sort of as a weapon. The pen is designed to fold and flex as opposed to another pen or a big pen or a metal pen that can actually be used as a more deadly device.
It's a safety concern for court deputies?
Yes.
Can I just have a moment?
Of course.
For the purposes of this trial next week, what is the type of restraint that court staff deemed is appropriate for this case?
We will be utilizing the stun cuff, and actually this is a newer version. The older version is a much bigger, broader box. This one is a newer one. So we'll be using this one right here.
Thank you. Defense?
Good morning, deputies.
Good morning.
Now, you talked about the number of deputy or court personnel typically kind of staffed in the courtroom. Are you aware of what arrangements, if any, have been made in terms of staffing for this trial?
None yet.
So you don't know how many deputies potentially would be or won't be in the courtroom?
That's a question above my pay grade. Sergeants will have to figure that one out.
Understood. Now, you talked about two different devices, and you indicated that the stun cuff is the intention in this case, correct?
Yes, ma'am.
And is that because that's generally what's used in this courtroom, or because of what?
99.99% of the time, we always use a stun cuff.
So I want to talk a little bit about the leg brace, since you did talk about that. Now, this leg brace, this is a longer device. Like it's not as small as the stun cuff, correct?
Right. It's essentially a metal bar. It's pretty long and it has 4 straps.
And to your knowledge, is that comfortable or uncomfortable?
I would say rather a bit more cumbersome because it's strapped alongside the leg of the person, and if they stretch their leg, it'll snap shut.
So essentially, normal movements could cause it to lock up.
Yeah, as soon as the person stands up, it will lock.
And then the stun cuff, I know you talked about this being a smaller apparatus that goes typically closer to the ankle, correct?
Correct.
And depending on the type of pants or clothing that is worn by the person, that could affect the visibility of the item.
Yes. So normally, male inmates will always have long pants, and the cuffs go right around it, so you really can't see it.
But the pants legs would have to be wide enough to kind of flow and fall over so it wouldn't be visible, correct?
Yes, and we always apply to the right leg, which is furthest away from the jurors.
And typically when sitting down, your pants often rise, generally speaking, correct?
Yes.
And so if the pants are shorter, then the stun cuff at that point would be visible, likely?
Possibly.
And those straps, I know we saw kind of like the strap that goes around. Where does the extra, so to speak, of that tuck in, or does it tuck in somewhere?
So when you apply this apparatus, it wraps around, and then the strap goes through here, so it holds it down.
So similar to a belt, you know how when you use a belt and you have the extra, where would you tuck in, or where does that extra strap go?
It just remains there, and it just folds in.
So would it be secured, or would it be kind of sticking out?
Just stick it out right. I mean, you would really have to look for it to find it.
Okay. Now, you talked about the two-step process with that remote for the stun cuff. I believe you said it was an on and a fire, correct? So does that mean that once the stun cuff is applied, it's typically automatically in that on position, and then you just have to go to step 2, or something else?
Well, the apparatus is turned on, so it's always going to be on. But to fire it, you have to press the on button again, and then press fire.
Okay. And those two buttons are, I don't want to assume, are they next to each other on the remote? Are they two different areas of the remote?
Yeah, so the on, and then you would have to switch over to fire.
So one side is on and one side is fire?
Right.
And I believe you said that typically one deputy has it, maybe between the 3 of you or 2 of you, depending on how many are in here. You guys would know, but none of the other court
Nobody
personnel.
knows who has it.
Just the person who has it, I assume?
Yes.
So you would know that you don't have it, and so if there's only 2 of you, by process of elimination, the other person would have it.
Correct. So essentially, when we do a courtroom operation, each deputy has an assignment. One is for the inmate, one is for the jurors, and one is for the security of everybody else.
Now let's talk about the writing utensil. You talked about this flex pen or the flexi pen, about how it's designed to collapse in on itself. Now this pen still does have a normal point, like that a ballpoint pen would have, correct?
Right.
Would the utilization of, say, a felt pen be something that would potentially not be a safety measure?
Well, we're not really concerned about the tip of the pen. We're concerned more of the body of the pen. It's a more firm structure to be used as a stabbing type weapon.
Okay. And with, are you familiar with felt pens? Okay. Now with those, typically that point, it's soft, correct?
Yes.
And with the flexi pens, And even with the stun cuff, those are only utilized for people who are in custody, correct? If an inmate who wasn't in custody was sitting at counsel table, he wouldn't have to have on, or she would not have to have on a stun cuff or a leg brace, correct?
Correct.
And writing utensil, if a person was out of custody, they also would not have to use a flexi pen, correct?
We normally give them flex pens as well.
Even a person who's out of custody?
Yes.
In terms of, I know you talked a lot about safety. Are you aware of any attempted escapes or anything like that for Mr. Sterns?
Of Mr. Sterns or any other inmate?
Mr. Sterns specifically.
No.
Can I have a moment, Judge? Any defendants complain about the comfort of the stun cuff or the leg brace?
No, so essentially, if the stun cuff, we put it not too tight, so it doesn't impede with blood flow or anything, or potentially injury, but it is placed snug, so this way it won't slip out. So, but we've not had complaints.
So no one's ever complained about like itching or discomfort or rubbing?
No.
What about with the leg brace?
I've not had much use of the leg brace. So the leg brace, to be clear, is if the courthouse has a number of jury trials of that day, and these stun cuffs are placed in the chargers, respectively, downstairs in our office, and whoever gets there first just grabs them, then we just have to go to the leg brace because there's no more stun cuffs.
Okay. And do you know how many stun cuffs the sheriff's office has in terms of within the courthouse?
Well, I believe we have 4.
And I know you mentioned staffing and things like that haven't been addressed yet, so you're not necessarily sure of the logistics of what potential other trials might be needing them?
So normally with big high-profile cases, there's a meeting with the judge, court, jury services, and sometimes our supervisors will be there just for logistics.
Okay. But I believe you had said that at this point, you're not sure if it's happened or you weren't a party to it.
Exactly. I have no knowledge of anything yet.
And then one more moment, Judge.
Of course.
And I know you mentioned not being aware of any like escape attempts or anything like that. Are you aware of any violent outbursts or any propensity for violence that Mr. Sterns has demonstrated during the course of his incarceration?
No, he's been quite compliant with everything we tell him to do, as far as just remain seated and come this way and sit down. He's not giving us a problem yet.
No further questions, Judge.
Correct. Deputy Rosario step down. Excuse me. Thank you, Deputy. Additional witnesses or evidence? Thank you. Defense argument?
Yes, Judge. Defense in this case is asking that Mr. Sterns be free of the inclusion of either use of the leg brace or the stun cuff, and we're also asking for the use of a regular writing pencil, specifically maybe a felt pen in this case.
Why? Why do you care what writing utensil is?
Judge, in prior experience, the flexi pens, they often skip, they often don't have ink, or they don't write well, so when a time is attempted to communicate, especially in an attempt to not use the microphone so that counsel can hear the questions that are being asked, having a utensil that writes and functions easily and freely as opposed to having to stop, well, not necessarily stop the proceedings, but trying to get a deputy's attention to get us another flex pen while we're also trying to watch what is being presented, listen for objections, or make any necessary objections. Essentially, it's a distraction if we're having to make sure that his pen is working, he's able to communicate with us, or being able to read it if it's skipping, so we're trying to figure out essentially what are the holes in the bubbles of what he's writing. Generally speaking, the flexi pens in the past haven't been the best. And I understand, kind of like a regular pen, you grab one out of the box, if it works good, it works good. So we're asking for like a felt tip, and I understand the defense's position that the use of a felt tip pen, being as a soft tip, it's essentially a marker, we would give it to him without the cap, would be sufficient. He would be able to write and communicate with us easily and effortlessly without having to worry about him stopping or not working and things of that nature. So we're asking for the use of a regular writing utensil, and we're proposing a felt tip pen to utilize. And then in terms of the restraints, again, we're asking for Mr. Sterns to be free of physical restraint. I understand the policy of the sheriff's office and things of that nature. However, it's supposed to be looked at as a case-by-case basis, not a general policy that applies across the board. There's been no testimony of any escape attempts, any propensity to violence during the course of incarceration. However, the deputy actually testified to the opposite, that Mr. Sterns is compliant, that he listens, follows directions, does what it is that is asked. So, and I understand the staffing issue. However, at this point, they're not aware if the number of deputies that will or won't be in the courtroom anyways. So the defense is asking that Mr. Sterns be free of physical restraints, because if he was out of custody in this case, he would not have physical restraints. I know the deputy testified that typically people who are out of custody also use flex pens. That hasn't generally been my experience in this courtroom, but that could have changed since the last time I've done a trial here in this courtroom. So the defense is asking that Mr. Sterns be free of physical restraints and utilize regular writing specifically of
Yes, Your Honor, the state provided testimony through Deputy Rosario, who testified as to what type of restraint would be used for this trial should the court deny the motion. The process of utilizing that stun cuff. Also, he testified as to any potential safety concerns with this being a felony criminal trial, and also any safety concerns with the type of writing utensil provided. The state would request that the court deny the defense's motion.
Thanks. Can I see one of the safety plans? Do we have one? All right, for purposes of the record, I'm holding one of the safety pens. They basically the internal tube that has the ink in it, and it's surrounded by a clear rubber tube, fairly flexible. They're also about 3 inches long. Look essentially different than the writing instruments that the attorneys would be using. All right, we're not, on the traffic motion, we're not in uncharted territory. There's some case law that applies to this case. Weaver v. State, 894 2nd 178. It's a Supreme Court case from 2004. In that case, there was a defendant that was charged with a serious crime. In the appeal, they took issue with the electronic restraining device, a belt in that case. In that case, the defense cited United States v. Durham. It's 287 Federal 3rd 1297, 11th Circuit 2002 case. In that case, the 11th Circuit indicated that a stun belt poses a greater threat to the dignity of the courtroom than shackles. That was based on a potential that it is reasonable to assume that much of a defendant's focus and attention when wearing a stun belt is occupied by anxiety over a possible triggering of the belt. Interestingly, in that case, there was an accidental discharge of the stun belt that occurred outside of the presence of the jury. Florida Supreme Court in that case found that the judge's discretion in exercising of the discretion to wear a stun belt was warranted. However, in that case, the defendant was pro se and was permitted freedom of movement about the courtroom. So the court in the Weaver case surmised that there was no lesser alternatives other than the stun belt to allow freedom of movement. as well as accomplishing the concerns, which was a concern regarding escape or proximity to the attorneys, the jury, and the court. In this case, we do have an alternative. The court has never had an accidental discharge of the stun cuff. The court has not before had any indications that the stun cuff was visible to the jury. The court before has never been presented with the argument that a defendant was preoccupied by the wearing of the stun cuff. But in this case, Mr. Sterns will not have freedom of movement in the courtroom. The use of the leg brace, the court as well has never received a complaint about the comfort of a leg brace. Because Mr. Sterns will not have freedom of movement, the court's heard no prejudice to the fair trial proceeding to have Mr. Sterns wear a leg brace that would, in the unlikely event that not be compliant and stand up and make an effort to exit the courtroom, that would lock and give the resources that are on hand an opportunity to intervene. The court understands that these matters should be considered on a case-by-case basis. The court can see no prejudice. The device will not be visible. The court has not before received a complaint about the comfort of that particular device. And the fact that Mr. Sterns will not be permitted to move about the courtroom anyway, the court can't find that would be prejudicial, and the court finds that a consideration of, due to the layout of this courtroom, proximity to the jury, proximity to the exit of the courtroom, and the severity of the allegations, and the emotional nature of the matters, surely to be presented that a leg brace is warranted and will be ordered to be implemented while he is present in the courtroom. We also have a private area that can be outfitted, and I'll address continuing concerns moving forward. That is going to conclude our hearing. Use of the pen. He'll be provided with a felt pen. I'm going to ask that that be specific to Mr. Sterns. That will remain in the courtroom. When he comes and goes, he can have the flex pen in the back if he needs to write notes while we are not present in front of the jury. The court understands the concerns of the deputies, and I sympathize with that. The layout or the construction of the flex pen is different than the construction of ordinary pens. I fear that it may create a question in the mind of the jury as to his departure status. That would be prejudicial. So he'll be provided with a felt pen and just leave it on the table. Any further?
Just a logistical matter, Your Honor. We are intending to bring a whiteboard or TV for the presentation of evidence next week, so as to protect as much as we can the sensitive nature of the material that we must show to the jury. So logistically, I just wanted to bring it to the court's and defense's attention.
Will this be on a cart?
Yes. It's on wheels.
So what do you need from me? Place to put it?
We can bring it up when we are intending to use it. I just wanted the court to know, because I know sometimes the court is going to need to get down to view the evidence. I anticipate that we'll put it over closer to the jury so that the family, who is also potentially going to be present, will not have view of it. Also, other individuals in the courtroom.
Understood. Thanks, I understand. Evidence is obviously of a sensitive nature and is unlawful in and of itself. I am happy to provide the courtroom on the afternoon of the 21st if you want to wheel your equipment up or have your tech folks do so. Gameplay how you would like to present that. The attorneys will obviously have an opportunity to move about the courtroom as they need to observe evidence. Mr. Sterns also has a right to view the evidence being considered against him. So we're going to have to accommodate all of those competing interests to ensure that the jury has an opportunity to review the evidence that the state intends to present. Does the state intend to close the courtroom or request a closure of the courtroom during the presentation of any testimony or evidence?
Your Honor, that is the intention of utilizing the whiteboards, that only individuals that have to view the content. We do not have a surviving victim to testify in this case, so I don't know that we necessarily have a right to close the courtroom for any of the proceedings. However, due to the sensitive nature of the material that is going to be presented in the form of actual videos and photos and things, the state intends to utilize the whiteboard in an effort to prevent other individuals that do not need to see that evidence.
I anticipated some of the evidence was multimedia, and I didn't know whether that had sound or what the position was going to be.
There are, I believe, 5 counts that are video with sound.
If the state makes a determination that closure of the courtroom is warranted pursuant to statute and victim rights, Marcy's law, I'll ask that's your intention. You present that in writing, and we'll address that. Give the defense an opportunity to weigh in on that request.
Yes.
Thank you. That's,
I believe those are all the
thank you. But, as I said, the court will make itself available for the rest of this week and on Monday for access to the courtroom. If you have specialized concerns, equipment concerns, please be proactive in asking in advance and resolving those issues with court staff prior to jury selection beginning on Tuesday, the 22nd. That'll conclude our hearing. Thank you. Are you going to provide the self-care?
Yes, Judge, we can provide those.
All right, so we'll run those, bring them in and let the justice take a look.
Is it for blue or black? Color preference?
To you guys.
Yeah, I was going to put it back. Yep.
I need to know what this is and what's going on.